I've been asked to call the Gutierrez matters out of order. The state of Nevada versus Jose Gutierrez. He appears to be present in custody, represented by counsel. Your appearance, counsel?
Yeah, good morning, Your Honor. Thomas Moskowitz, bar number 12620 on behalf of Mr. Gutierrez.
And you're confirming as counsel?
I am confirming today, Your Honor.
On behalf of the state?
Giancarlo Pesci on behalf of the state.
All right, a couple things. He has two cases. I put the other case on calendar today to coincide. They are related cases. Mr. Gutierrez was originally arrested under case number 25PC 100298. He was arrested on November 18th of this year for 4 charges of reckless driving resulting in death or substantial bodily harm. He posted a standard bail amount in the amount of $20,000 on that case before the case was reviewed by a judge. Before he was actually physically released, however, he was rebooked under case number 25CR 100657. The state has filed charges in that case, charging him with 2 counts of open murder with use of deadly weapon, 4 counts of reckless driving resulting in death or substantial bodily harm, 2 counts of attempted murder with use of deadly weapon, and 2 counts of battery with use of deadly weapon resulting in substantial bodily harm. So 10 felony offenses. He is currently being held without bail as a standard on a murder charge. I think the state probably should have filed under the lower case number. I see that both of those cases, however, were assigned to the same Justice Court Department. Coincidentally, they were assigned to Justice Court Department 3, Judge Letizia. Judge Letizia did review this yesterday. Based on the filing of reckless driving felony charges, it triggered the administrative order reassigning it to this department. So this department will proceed with this case. Is that the state's understanding? The state's not proceeding under the PC case number?
No, we're proceeding under the case that you indicated that's been filed in JC3 as far as how it's going from 3 to here. We submit that to the court. So we're proceeding under charges of the murder, 2 counts of murder.
All right, so the 25PC 100298 matter, that'll be taken off calendar. The bond in that case, I'm inclined to exonerate that. That'll be the order today. I'll next hear from defense counsel.
And Your Honor, we did pass the Valdez-Menace hearing to today from the initial bail hearing, Your Honor. Additionally, regarding the criminal complaint, my client and I have gone over. We're going to wait and read on that, and they're not guilty.
All right, thank you. You'd like to address custody status today, then?
Yes, I would, Your Honor.
All right, the state, I'll hear from you first.
So, Judge, the individual that before you represents a danger to this community. He's now charged with 2 counts of murder. I would add for the court's edification, there are 2 other individuals who are seriously injured. We hope that they will come through, but there is the possibility that something could go wrong with those other 2. So there are 2 counts of murder. This is a person who was driving the car exceptionally fast, at least over 71 miles an hour. There is no indication of any breakage whatsoever, and there is 0 alcohol in his system. We are proceeding under a murder charge using that deadly weapon of the car. We're asking for no bail.
You're asking that he continue to be held without bail? All right, next hear from the defense.
Yes, so, under Nevada law, Your Honor, if somebody charged with first-degree murder, they're not entitled to bail. But there is a burden of proof in order to declare somebody held without bail. And the burden of proof is, the proof is evident that presumption of rape on the first-degree murder charge. A lot of times in practice, when grand jury returns, those words are given some kind of talismanic qualities. If they're just uttered, the state has met that burden. I mean, here today, the prosecution really hasn't offered any evidence of the elements of first-degree murder being met other than a car being driven at least 71 miles per hour with no braking and no alcohol in the system. I'm sorry, but that's not enough to meet the proof is evident presumption of rape on a first-degree murder charge. This is a very strange case because a lot of cases with first-degree murder, you're dealing with somebody shooting a gun, stabbing, using some kind of deadly weapon. This is a particular case where they are alleging a very novel theory of first-degree murder here. And I think that the prosecution has to make a stronger showing on provability of the case when it comes down to bail in order to even ask for no bail. They have to present some kind of evidence that this charge is sustainable. and that the proof is evident, the presumption is great. That hasn't been done yet. I know Mr. President would have time to do the rebuttal there. As far as the risk bail factors, when we look at this pre-trial risk assessment sheet here, I understand this is a very serious case here, but they have him as a total score of 3. And 2 points of that comes because he had an arrest as a juvenile. Mr. Gutierrez, as it sits right now, is still, or not as a juvenile, but an arrest when he's 20 years or under. He's 20 years or under right now. So that's 2 points out of the 3. And then he has 1 misdemeanor conviction that's listed here, stemming from probably an arrest back in April, but no representation from the prosecution on that. My point here is this: if you look under scoring item number 8, mitigating verified stability factors, which would take a 2-point total deduction, they're saying unverified here as 0. I'll give some information to the court about Mr. Gutierrez. He's born and raised here in Las Vegas. He's lived his entire life here in Las Vegas. All of his family is here in Las Vegas. He has 4 siblings, correct? He has 4 siblings that reside here in Las Vegas. His biological mother is here in Las Vegas. His stepfather, married to his mother, is here in Las Vegas. His mother's grandparents are here in Las Vegas. I've been in contact with all these family members. His deceased father's grandparents, who he resides with and has been residing with here, live in Las Vegas. All of his family is here. As far as working history goes, he has been working construction for a while. He's a flagger. That's even indicated in the declaration of arrest. So he was a person who was working. He's a person who has little to no criminal history other than what's reflected as 1 misdemeanor conviction. I believe that I could be wrong about this, but I think that's a disorderly conduct that was charged as disorderly conduct, not something that was pled down to disorderly conduct. So little to no criminal history here. All of his ties in his life are to the Las Vegas community here. And really the only ask by the state here, they're asking for no bail. I'm sure they're going to ask for a high bail when we give them an opportunity if they had to ask alternatively. It's just the nature of the charges. And that's something you can take into consideration. But in the nature of the charges, we have to look at the provability of the case. And one thing, I've seen a lot of accounts in the media and what the DAs are alleging that this is a premeditated murder, and I'm looking at the charging document itself. And specifically, if we look to count 3, it gives a little bit of insight into what the state's theory of the case is. But they're saying in count 3 on page 2 of the charging document, under the count for Edward Garcia, that this was an attempt to kill Adeline Duran Rico, and that intent transferred to Edward Garcia. So Adeline Duran Rico was actually a passenger in Mr. Gutierrez's car. It's actually his fiance. And this theory of the case, just saying that he was driving fast with no braking, because he has no alcohol in his system, I don't know how they get to a place where, the provability of the case is high. For purposes here to bail here. If we were in the federal system, the prosecutor would start presenting a little bit of evidence in their case. And it would have to be a little bit higher burden than what we're seeing here. Mr. Gutierrez's side, I'll say this, and this is also in the declaration of arrest that the judge reviewed at the PC hearing. If you look at the declaration of arrest, we can look at page 4 or 5 of the declaration of arrest, the 3rd paragraph. I'll direct the court's attention to the last couple of sentences here. When he was interviewed by police, he has no recollection of the accident. He has no recollection of the events leading to the accident. He has no recollection of getting into the car, of picking up his fiancée. He suffered a concussion. It was a violent collision. But when we look at the last paragraph, he advised detectives that he's been experiencing seizures since the age of 5. And I talked to the family, and we're getting those records together now as quickly as we can, that he has been having seizures occasionally, even this year. He's had at least 1 documented seizure this year. And so our position in the case is this really doesn't make any sense other than he suffered a seizure while he was driving, and that's why the accident happened. Now that's a tragedy. I'm not saying there's not any criminal liability there, but it's a huge problem for the state when it comes to provability on first-degree murder charges here. And I would implore the state, regardless of what the bail decision is here today, I would implore the state, and I'm going to submit information over to the DA's office so we can start gathering some documentation of medical records so this can be taken into consideration in this case before the state just plows forward ahead on Mr. Gutierrez on first-degree murder. And I will also put the state on notice and make it part of the record here today that if they are going to go seek indictment to the grand jury, that they give me an opportunity to get this information over to them to be presented to the grand jury. To me, this is a vehicular case. I think that I don't blame the state or fault the state for moving forward quickly based on the evidence that they have. But I think they have a problem with the bail hearing, establishing right now today that the proof is evident and the presumption is great. If they don't do that, he's entitled to a monetary bail, he said. And he's entitled to a monetary bail, he said. Then you take all the factors that I put forth before, it really should be a total risk score of 1 on this with a manual override. Now, I'm not saying that you just bar him on first-degree murder charges. There's a huge penalty that he's facing there, but at least take that into consideration. He would be indigent if not for his family being able to step in and retain counsel on his behalf. So I would ask, his original bail was set at $20,000. He exonerated that in the first case that's not being proceeded on today. His family did post that. I mean, at 15%, that's about $3,500. I would ask for a reasonable bail to be set, something that could be made. Otherwise, the court would pretty much be holding him on a detention order under $1,000 minutes. And I'd ask for the proper findings there. If we go to community safety and risk of flight, they really can't show any risk factors of flight other than the charge itself and the potential penalty coming from that charge. I've addressed the proof issues that I think are going to come forward in the case on that regard. To community safety, they really can't address anything regarding community safety other than the driving conduct in this case. Your Honor, you hear all of the vehicular cases here in Clark County. You hear about 200 a day. Okay? There is a way to address community safety other than holding a person in jail. And I think the state asks for people to be held no bail and held in high bails whenever it's a serious case. Whenever there's a death involved, all of a sudden they ask for $250,000, $500,000, no bail on cases. That being said, we see a lot of DUIs here in Clark County. You've got guys that come in here every day, defendants who have multiple DUIs, and the state doesn't ask for any bail fees. And they're equally, if we look at it, threats to the community in that regard. Here, they're not even charging Mr. Gutierrez with DUI. I think the court could fashion something that could protect the community other than just holding him in jail. I think that the jail decision to hold him on a detention order would be all geared toward risk of flight. Community safety can be addressed through house arrest, through a strict no driving order, to where if he violates any condition of that, he would be held no bail at that point under the statute if he can't comply with the court's conditions. So that would be my ask there. I'll also ask the court to make the finding, unless the prosecutor makes a further showing here today, that they have not established the proof is evidence and presumption is great. And I would also ask the court to make the finding that they have not established that a detention order is necessary in this case regarding community safety. I'll submit it on that.
Judge, here's the evidence. He's talking about evidence. We've got an exhibit here that has 3 videos of the actual incident. It has to be marked as an exhibit for the court to review. No doubt you've seen it. It's been on all the news. Anybody can see it. This is a person who drove a car over 70 miles an hour who has not a single drop of alcohol in his system. You can use a car just as effectively as a deadly weapon, a firearm. This is an individual, if we accept the representations that were just put forth by defense counsel, who allegedly had a seizure, has no business driving in this community. He has no business being released out onto the street if that was his condition and that caused the situation. We have a person who's killed 2 people. He's seriously injured 2 other people who didn't do it because he was drunk. And we have potentially the idea of the seizure. We also have the idea that he was intending to end the relationship that he had. And that's in fact what happened because she's now dead. We can deduce these facts, but what we definitely know is he used the car in a deadly fashion and killed 2 people. It's on video. That's the proof evident and the presumption great. He should not be released. He represents a danger to this community.
All right, thank you. I'll note a few factors. I acknowledge his ties to the community. My understanding is he has some family members in the courtroom today. I'll also acknowledge that the victims have some family members in the courtroom today. I do see that he does have some history at the age of 19. He has a number of cases with the Las Vegas Justice Court from December 3rd, 2023, a violation of instructional driver's permit. I believe that was when he was a juvenile. More recently, from October 3rd of 2025, a citation for speeding. These were both civil infractions. I see another criminal case, which is likely the misdemeanor mentioned in the risk assessment. I see that he was arrested on April 12th of this year for a felony intimidating public officer with the threat of force. That was amended to a misdemeanor. He pled to that and did complete requirements. That case was closed on September 22nd. He was originally arrested on 4 counts of reckless driving here. However, the state has now alleged some intentional conduct and has in fact charged 10 felonies, including 2 open murder charges with use of deadly weapon. It's my understanding 2 individuals did die as a result of this. My overwhelming concern at this point, at this early stage of the proceedings, is the potential penalty, is the nature of the charges. I am entering a finding that the state has met their burden for a no bail hold at this stage of the proceedings. This may be readdressed at a future court date depending on how this proceeds. The state has submitted some video evidence to the court. That'll be reviewed. I'd be inclined to set the matter for preliminary hearing within 15 days. Is that acceptable, counsel?
It is, Your Honor.
All right, the matter is set for a preliminary hearing within 15 days. Counsel will be in contact with Mr. Gutierrez. He'll be back on this case on this next court date.
December 9, 9:30.
Thank you, Judge.
Thank you.
Thank you, Your Honor.